Welcome back, students, in Legal Studies Class 12th, Unit 1. This is the Part 2, Judiciary. In the previous video, we already discussed about what is judiciary. On that video, I explained why there is need a judiciary, what is judiciary, and what is the role of the High Court, Supreme Court, how judges are appointed, what is the role of the High Court, where are these high courts located, subordinate courts, how subordinate courts are working in their places. Let's review about this syllabus. In this syllabus our topics are Constitution, roles and impartiality, structure, hierarchy of courts, legal offices in India, appointment, training, retirement, removal of judges, and judicial review. These topics are under the judiciary. What is the role of the Constitution? It's interpretator, adjudicator, advisor, guardian of the fundamental right, and activist. These all 5 roles are playing Constitution. Next is impartiality. Through the concept of judges, impartiality is distinct from the independence of judiciary, but both are pretty interlinked with each other, as the independence of judiciary ensures the impartiality of judges. Always courts are doing the impartiality. Let's start our new topic. Our new topic, already I explained the Indian judiciary, so our new topic is salient features of the Indian judiciary. You know what is judiciary? So now we will be discussing about their features. Our first feature is single and integrated judicial system. The Constitution establishes a single integrated judicial system for the whole of India. The Supreme Court of India is the highest court of the country, and below are the High Court at the state level. Other courts work under the High Court. The Supreme Court controls and runs the judicial administration of India. All courts in India form links of a single judicial system. The Constitution of India provides for a single integrated judicial system with the Supreme Court at the apex, High Court at the middle level, and District Court at the local level. It also protects for an independent and powerful judicial system. Judiciary in India acts as the guardian protector of the Constitution and the fundamental rights of the people. Second is independence of judiciary. The Constitution of India makes judiciary truly independent. It provides for appointment of judges by the President, high qualification for appointment as judges, removal of judges by a difficult method of impeachment, high salaries, pension and other services, benefit for judges, independent established for the judiciary, and adequate powers and functional autonomy for the judiciary. Third point is judiciary as the interpreter of the Constitution. The Constitution in India is a written and enacted constitution. The right to interpret and clarify the Constitution has been given to the Supreme Court. It is the final interpreter of the provision of Constitution of India. So, you know, the students, judiciary is the interpreter. Fourth is judicial review. The Constitution of India is the Supreme Court of land. The Supreme Court acts as the interpreter and protector of the Constitution. It is a guardian of the fundamental right and freedom of the people. For performing this role is it exercise and powers of judicial review. The Supreme Court has the power of determining the constitutional validity of all laws. It can reject any law. Fifth is High Court for each state as well as provision for joint High Court. The Constitution lays down that there is to be High Court for each state. However, two or more states can be mutual consent have a joint High Court. Which are joint High Courts? Punjab and tell me, I think you all your students have rewinded it. Let's come on sixth point. Supreme Court as the arbitrator of legal disputes between the union and states. The Constitution gives to the Supreme Court the jurisdiction in all cases of disputes between the Government of India and two or more states, between the Government of India and any state or state on one side, and one or more states on the other, and between two or more states. That topic already we have discussed in the previous video and as well as 11th class. Seventh is guardian of fundamental rights. Indian guardian act as the guardian of fundamental right and freedom of the people. The people have the right to constitutional remedies under which they can seek the protection of the court for preventing a violation or for meeting and threat to the rights. The Supreme Court and High Courts have the power to issue writs. Eighth is separation of judiciary from the executive. The Constitution of India provides for a separation between the judiciary and the other two organs of the government. The judiciary is neither a branch of the executive nor in any way subordinate to it. The judicial administration in India is organized and run in accordance with the rules and orders of the Supreme Court. Ninth point is open trial. The court in India are free. These conduct open trial. The accused is always open full opportunity to defend himself. The state provides free legal aid to the poor and needy. Open trial, you can, that is a good example nowadays going. That is that coronavirus and people, government is helping their legal aid and their requirement. 10th point is judicial activism. Indian judicial system has been becoming more and more active. The Supreme Court has been coming out with judicial decisions and directive aimed at active protection of public interests and human rights. Judiciary have been giving the directives of public officials for ensuring better security for the rights of the public. So 11th is PIL. Under the system of the court of law in India can initiate and enforce action for securing any significant public or general interest which is being adversely affected or is likely to be so by the action of an agency, public or private. With all these features in Indian judicial system, an independent, impartial, free, powerful and efficient judicial system. 12th is common law jurisdiction. Judiciary can make law through judicial decisions of courts, and these decisions are binding or subordinate courts in hierarchy. Other countries like Germany, Russia, continental Europe, etc., that civil law system in which only legislative and executive has law-making power. Our next topic is Legislative Council and Legislative Assembly. Do you know what is Legislative Council and Legislative Assembly? In a state where are two houses, there is a state legislative council, means Vidhan Parishad, and a state legislative assembly means Vidhan Sabha. In such a case of legislative council is the upper house while Legislative Assembly is the lower house of the state legislature. For every state, there is a legislature which consists of governor and one house or two house, as the case may be. You can see in this map like Uttar Pradesh, Bihar, Maharashtra, Telangana, Karnataka and Andhra Pradesh. So, do you know who is the legal officers in India? There are two types of legal officers in India. First is Attorney General of India and second is Advocate General in every state. What is the difference between Attorney General and Advocate General? One is for state and one is for India. So first we will start from the introduction. The law officer fundamentally are the legal advisor of the government. At central level, the law officer is known as the Attorney General of India. And at the state level, the law officer is known as the Advocate General. Central General means Attorney General. Central Advocate means Attorney General. Or state level means Law of General. So those people are working for the state level, that is called the Attorney General of India. Attorney General of India, that person is Indian government's chief legal advisor. Attorney General of India is the chief legal advisor of the government of India and is primary lawyer in the Supreme Court of India. He is an advocate from government side and the first law officer of the country. At present, K.K. Venugopal is the Attorney General. He is the 15th Attorney General and was appointed by the Pranab Mukherjee, the President of India at that time. जब प्रणब मुखर्जी थे उस समय के वेणुगोपाल को अटॉर्नी ऑफ जनरल डिक्लेयर किया, अपॉइंट किया, और that only Attorney of General is the law officer for the state government. How they are appointing in our country? As per the Article 76(1) of the Constitution, the President shall appoint a person who is qualified to be appointed a judge of the Supreme Court to be Attorney General for India. जो ये सारी क्वालिफाइड हो वही पर्सन, उसी पर्सन को प्रेसिडेंट अपॉइंट करता है. What is the duty of the Attorney General of India? It is given in the Article 76(2) states that it shall be the duty of the Attorney General to give advice to the Government of India upon such legal matters and to perform such other duties of a legal character as may from time to time be referred or assigned to him by the President, जो कि President के according ही चलता है, and to discharge the function conferred on him by or under this Constitution or any other law for the time being in force. जो कॉन्स्टिट्यूशन के अकॉर्डिंग उसके जो फंक्शंस होते हैं और प्रेसिडेंट जिसे प्रेसिडेंट असाइन करता है वो सारी इसकी ड्यूटीज होती हैं. ड्यूटीज ऑफ अटॉर्नी जनरल ऑफ इंडिया, दैट इट शैल बी द ड्यूटी ऑफ द अटॉर्नी जनरल टू गिव एडवाइस टू द गवर्नमेंट ऑफ इंडिया. ही इज द लीगल एडवाइजर टू द गवर्नमेंट ऑफ इंडिया upon such legal matters and to perform such other duties of a legal character as may from time to time be referred or assigned to him by the President. What is the duty? Duty is the right to India has the right to participate in the proceedings of the Parliament, but without voting right. On behalf of the Government of India, Attorney General appears in all type of cases in the Supreme Court in which Government of India is concerned. Some notes are there. Attorney General of India is not a government servant. Hence, he is not debarred from private legal practice. However, he is not allowed to appear in any case which is against the government. Besides, he cannot defend any accused to the criminal proceedings, nor he can accept the directorship of a company without the permission of the government. That is the duty of the Attorney General. Next topic is Solicitor General of India. Who is the Solicitor? The Solicitor General is the below the Attorney General for India, who is the Indian government's chief legal advisor and the primary lawyer in the Supreme Court of India. The Solicitor General of India is appointed for the period of 3 years. He is appointing only for the 3 years. The Solicitor General of India is the secondary law officer of the country. First is Attorney General, second is Solicitor. He assisted the Attorney General and is himself assisted it. Like the Attorney General of India, the Solicitor General and the additional Solicitors General advise the government and appear on behalf of the Union of India in term of the legal officers. However, unlike the post of Attorney General for India, which is a constitutional post under Article 76 of the Constitution of India. Next is Advocate General. The Advocate General is the chief legal advisor of the state government and is primary lawyer in the respective high court. He is an advocate from state government side and the chief law officer of the respective state. Advocate General is the different. Advocate General is the chief legal advisor of the state government. Who is the central? Attorney General. Second is, who is the second? Second is the Solicitor General. Those are the below the Attorney General. How appointment of the Advocate General? Article 165(1) of the Constitution states that the governor of each state shall appoint a person who is qualified to be appointed a judge of a high court to be Advocate General for the state. Next is duty of Advocate General. What are the duties of Advocate General? That is given in the Constitution, Article 165(2). It states that it shall be the duty of the Advocate General to give advice to the government of the state upon such legal matters and to perform such other duties of a legal character as may from time to time be referred or assigned to him by the governor, and to discharge the function conferred on him by or under this Constitution or any other law for the time being in force. So it means What are the duties of the Advocate General? He is also the legal character. But every advocates have the different type of criteria for the doing their legal matters. One is for the state, second one is for the assistant for the state, third one is for the central, below second Advocate General, those are the advocates. That in the article 177 states that every minister and the Advocate General for a state shall have the right to speak in and otherwise to take part in the proceedings of the legislative assembly of the state, or in the case of a state having a legislative council. Just now I explained it. And both houses, and to speak in, and otherwise to take part the proceeding of any committee of the legislature of which he may be named a member, but shall not by virtue of this article be entitled to vote. I think your concepts are clear about these legal officers. Students, our next topic is Constitution, roles and impartiality. What is the meaning of the Constitution, roles and impartiality? The judiciary in India derives its power and function from the Constitution, which till date remains the fundamental legal text for the functioning of Indian democracy. Three essential bodies exist in any state: the executive, the legislature and the judiciary. In the doctrine of separation of power, there should be a clear demarcation of function between these three institutions to avoid arbitrary or dictatorship. What is the role? Role means the interpretator, adjudicator, advisor, guardian of fundamental right, activist. These five are roles of the Constitution. And what is impartiality? Impartiality means, though the concept of judges, impartiality is distinct from the independence of judiciary, but both are pretty interlinked with each other, as the independence of judiciary ensures the impartiality of judges. Judiciary. What is judiciary? Interpretator, can see the picture. Adjudicator, mention in the picture. Advisor, guardian and activist. I arrange some pictures related to that word. Who is the interpretator, adjudicator, advisor, guardian and activist? Let's come on next topic, that independence of judiciary. The judiciary's independence in fact is ensured by the Supreme Court of land, that is Constitution. The Article 50 of the Constitution separates judiciary from the executive. Further, to maintain the principles of rule of law, the judicial independence is necessity. On the top of this, given such a responsible position, the judiciary needs to work in an independent atmosphere so that it can take unbiased and impartial decision. That is why it is independence of judiciary. How to ensure the independence of judiciary? Appointment of judges. The appointment of the judges of the Supreme Court as well as High Court is a lengthy process. Though a judge of Supreme Court and High Court is appointed by the President on the advice of the Council of Ministers, especially by Prime Minister and Law Minister, and in case of High Court judges, to more persons, namely Governor and Chief Minister. However, the role of judiciary, especially of the Chief Justice of India and other senior most judges of Supreme Court, and in case of High Court, the Chief Justice of the respective High Court, is crucial. Basically, these judges shortlist the candidates. The President simply gives the responsibility. How to ensure the independence of judiciary? Security to the tenure. The tenure of an appointed judge is highly secured, and in normal circumstances he cannot be removed. Rather, he retires after attaining the age of 65 in case of Supreme Court and 62 in case of High Court. Removal of the judges. A judge can be removed only on the ground of the misbehavior or incapacity. However, the removal process of a Supreme Court judge, High Court judge is very complex and lengthy, that takes months' time. The removal process can be done only after process, investigation, and then passing the removal motion in the Parliament with 2/3 majority present and voting. So that process is very lengthy. Fourth is restriction of law practice. A retired judge is not allowed to practice as advocate in the same or equivalent court. So a retired judge of the Supreme Court cannot practice in any court, including the Supreme Court. However, a retired judge of High Court is restricted to practice in the same High Court from where he retired and all the lower court of India, but he can practice in other High Court or in the Supreme Court of India. This ensures that ex-judge practicing at the bar does not influence the decisions of the bench with whom he may have presumed familiarity. When any judge is doing work, so their restrictions are with them. How to ensure? The salary and the allowance of judges are fixed and not to subject to vote of the legislature. The salary of judges are fixed and cannot be altered in normal circumstances. So I think you all clearly what is the how to ensure the independence of judiciary. Fifth is the salary and allowance of judges are fixed and not the subject to vote of the legislature. The salary of the judges are fixed and cannot be altered in normal circumstances. Principles of non-interference by other branches of government. The judicial conduct of the judges are immune from examination by other constitutional organs. The conduct of judges of the Supreme Court cannot be discussed in the Parliament, and the judges of High Court cannot be discussed in the state legislature, except when a removal motion is introduced in the House. Salary allowance, judges, everything I mentioned in this video. Seventh is judges' freedom. In respect of posting, promotion, transfer, disqualification, discipline, etc. are entirely in the hands of judiciary only. On top of this, the Supreme Court of India has been authorized to have its own establishment and to have complete control over it. Judges have the freedom to respect every post, promotion, transfer, disqualification, discipline. Those are entirely in the hands of the judiciary only. Category of judiciary's independence. First is personal independence. It means the judges are not dependent on government and in any way in which might get influence from them in reaching a decision in any of the cases. Second is functional independence. It means the judges are immune and hence can make any decision without submitting any sort of India or outside pressure. The judges have the power of these categories. Third is internal independence. Internal independence means the judges are judicial officers are independent to make their decision based on the given facts and evidence, and they are not obliged to follow any kind of order or indication or pressure from their judicial superiors and colleagues while deciding the cases. Fourth is collective independence. It means the institutional, administrative and financial independence judiciary as a whole. Impartiality of judges. Though the concept of judges, impartiality is distinct from the independence of judiciary, but both are pretty interlinked with each other, as the independence of judiciary ensures the impartiality of judges. However, the judges, who are the constituent actor of judiciary, are expected to be impartial, which means without personal bias or prejudice towards individuals while deciding the cases and delivering the judgment. Judge should apply the law uniformly and consequently to all persons by keeping Article 14 of the Constitution in mind. Which article? Article 14. Students, what is the role of the judiciary? In a constitutional democracy, the role of judiciary is essential, significant as ensure the democratic characteristics of the governance and at the same time also protects the fundamental rights of the individuals. First is to interpret the complex or lengthy provisions of the Constitution. Last year I have explained this. Second is uphold the federal principles of Constitution by maintaining the check and balance among all three organs of the government. Third, to maintain and keep functional the principle of rule of law. Fourth is to maintain the harmonious relationship between center and the state as well as between two or more states. So, Judiciary is maintaining the relationship between law, relationship between central, relationship between states, and role of the judiciary is to protect the fundamental rights of the citizens. How they are protecting? They are protecting through the judges, they are protecting through the laws, they are protecting through the giving advice. They are to advise the government whenever required, to interpret the legislative acts and laws, to test, verify, and based on the result validate and the legislative, quasi-legislative, executive, judicial or quasi-judicial action as per the mandates of the Constitution, to apply the relevant laws while adjudicating the cases, and last is, if need arises, then protectively take action and can give direction to the government or other such authority in favor of the interests of the society at large. So, firstly I started what is judiciary, then I started types of the courts, and which is for the central three types of courts are, where they are located, etc. Then after I completed the role of the judiciary. Thank you.